of Williamson County for 3 decades. Oh, okay, thank you. For 3 decades, I traveled the state defending parents against over-aggressive child removals. My background includes multiple appeals, 2 historic Tennessee Supreme Court opinions, and carving out civil rights for citizens in the Sixth Circuit Court. This bill will give DCS more power over parents and pushes constitutional limits. It is consistent with my opinion that often criminals have more due process rights than parents. First, it is an unconstitutional reversal of the burden of proof on parents. Second, it seeks to sever parental relationship based on a profound but ambiguous standard of some future psychological event. 1, it reverses the burden of proof in an action against parents, saying that the court must find that a parent can be excluded by clear and convincing evidence before a parent can have access to their child after a finding of severe abuse. To you, severe abuse may sound devastating. However, an accidental injury causing a fractured bone could be taken as severe abuse. This bill means that a parent must prove they are innocent. Ms. Moore is going to speak to you about her case in the Tennessee Supreme Court opinion, which came out in May 2023, in which this bill will reverse what the Supreme Court solidified for parents. That mother has been separated for 9 years. Number 2, the bill allows for a diagnosis of a potential future psychological event, providing that DCS can bring an expert to reasonably expect or predict such a future event. The conclusions are made by experts who are paid by the very agency who wants to terminate parental rights. Tennessee's vulnerable population of parents that do not have resources to hire their own experts and can rarely even hire their own attorney. Sadly, Tennessee has a dearth of constitutional attorneys. The challenge in the courtroom is too arduous and there's no money in it. But you have a constitutional duty as well. Remember that unnecessary parent-child separation is well established as a predeterminant for severe anxiety and long-term psychological abuse for children. This bill should be rejected as written. I thank you.
Very good, and thank you for that. Members, do we have any questions or comments for our guests? Seeing none? Oh, excuse me. Representative Bricken, you're recognized, sir.
Thank you, Mr. Chairman. You know, there's probably a little truth to your statements. Certainly, government-granted power seems to overstep their hand too often, and that does scare me. And I think DCS is probably extremely capable of overstepping their bounds. But is there anything in this bill that you can get behind, or is there pieces that could just be modified that you could get comfortable with?
Yes.
Ms. Reguli, you're recognized.
Thank you for asking that. Yes, I think, and 3 times in the bill it says that the court has to, by clear and convincing evidence, exclude a parent or anybody as a perpetrator. That is a reversal of the burden of proof that needs to be stricken. It's in there 3 times. The second one is this very specific provision that the psychologist can come in and say that we expect there might be some psychological damage. Unfortunately, there is some similar language like that currently, and I've seen the damage where they're trying to predict a psychological event. So unless they specifically articulate the factual basis which would lead, and there's some scientific evidence to show that it's going to result in that psychological event, then it might be able to be supported. But as it's written, it's merely somebody can just come in and give a mental health opinion or a psychological opinion. It needs to have a factual basis. For instance, let's say a child, and I've seen these cases, that they're locked in the closet for weeks, months, whatever, okay? There are some serious cases where somebody must be able to first articulate the findings of fact before they jump to that next section. The rest of the bill, I don't, I've read through it. I don't really have a lot of major objections. I'm a little bit concerned about the substance or the drug issue, because it says if there are any drugs that are listed in this one section, that are just present and available that a child might have access to that could be severe abuse. And that list is so broad. It includes depressants, it includes ADHD medication, anything that it's a prescription-oriented medication, like an opioid, a stimulant, or a depressant. I think that's just a little bit too broad, because parents wouldn't even know that that's an issue.
Representative Bricken, any follow-up?
No, thank you for the explanation.
Very good.
Certainly.
Members?